My dear student, today we will discuss very important topic on international humanitarian law. The topic is prohibition of use of weapons and methods of warfare. Let's start from introductions. There is a common saying that in war and love, everything is fair. In this regard, we may ask certain questions. Is the law of any value on the battlefield, or was Cicero right when he skeptically said, quote, "Laws are silent amidst the clash of arms"? But everything is not fair in war. Laws are not silent amidst the clash of arms, and limits are prescribed by the rules of law, that is, law of war, or accurately, the law of conduct of war, or in a more polite way, you can say international humanitarian law. Limits on the way war are waged have existed for centuries. That we understood from some of the epics like Ramayana, Mahabharata, Manu's writing, and China roll, that is a so-called Puya, ancient scriptures of Manipur, in Manipuri script, and the idea of cavalries. Effort by international community to introduce effective legal limit on the conduct of war began seriously in 19th century. International law relating to the limitation of warfare date back to the Hague Conventions of 1899 and 1907, the first codification of this area of law. For this reason, it is still called Hague Law. The general principles on limit on warfare are enshrined in the Hague Conventions of 1907 and the 1949 Geneva Conventions and their additional protocols of 1977. But there are other treaties covering specific issues, particularly in the field of weapons. In 2005, the International Committee on Red Cross published a major study on the extensive body of customary international humanitarian law prescribing use of weapons and its limit on warfare, which is binding on all states. Under international humanitarian law, the term means of warfare commonly relate to the regulation of weapons, and the term method of warfare cover a broad array of rules designates the way or manner in which weapons are used. The concept of method of warfare also comprises any specific tactical or strategic way of conducting hostilities that are not particularly related to weapons and that are intended to overwhelm and weaken the adversary. So my dear student, we'll see what are the basic rules of this means the method of warfare. So basic rules is stipulated in Article 35 of Additional Protocol 1. This article repeats two existing principles of the law of Hague and also add one more new principles. So principle 1 says, in any armed conflict, the right of the parties to the conflict to choose method or means of warfare is not unlimited. It means limited. Principle number 2. It is prohibited to employ weapons, projectiles, and material and method of warfare of a nature to cause superfluous injury or unnecessary suffering. The third principle. It is prohibited to employ methods or means of warfare which are intended or may be expected to cause widespread, long-term and severe damage to the natural environment. So these are three basic principles on method and means of warfare. And next, let us see prohibited or restricted use of weapons under international humanitarian law. International humanitarian law contains basic principles and rules governing the choice of weapons and prohibit or restrict the employment of certain weapons. So let us see an overview of the weapons that are regulated or prohibited by ISL treaties. Explosive projectile weighing less than 400 grams are prohibited by Declaration of St. Petersburg, 1868. Explosive bullets, dum-dum bullets, are prohibited by Study on Customary International Humanitarian Law, Rules 78 and 77. Bullets that expand or flatten in human body are banned by Hague Declarations of 1899. Poison and poison weapons are prohibited by Hague Regulations of 1907. Chemical weapons are regulated by Geneva Protocol of 1925 and Convention on Prohibition of Chemical Weapons 1993. Biological weapons are regulated by Geneva Protocols of 1925 and Convention on Prohibition of Biological Weapons 1972. Weapons that injure by fragments which in human body escape detection by X-ray, that is non-detectable fragments, are prohibited by Protocol 1 of 1980 to the Convention on Certain Conventional Weapons. Incendiary weapons are prohibited by Protocol 3 1980 to the Convention on Certain Conventional Weapons. Blinding laser weapons are prohibited by Protocol 4 1995 to the Convention on Certain Conventional Weapons. Mines, booby traps and other devices are also prohibited by Protocol 2 as amended in 1996 to the 1980 Convention on Certain Conventional Weapons. Anti-personnel mines are regulated by Convention on Prohibition of Anti-personnel Mines. In short, we can say Ottawa Convention of 1997. Explosive remnant of the war are regulated by Protocol 5 of 2003 to the Convention on Certain Conventional Weapons. Cluster munitions are regulated by Convention on Cluster Munitions 2008. And there are other weapons which are under consideration of international society for regulations and ban. These weapons are light weapons, anti-vehicle mines and fragmentation weapons. Till date there is no such banning of such weapons, but these are under consideration by international community. Next, let us see what international humanitarian law says about nuclear weapons. Neither the Geneva Conventions nor additional protocols make direct reference to the legality of nuclear weapons in armed conflict. The judgment of International Court of Justice in nuclear weapon case is an authority to this regard. The International Court of Justice concluded that a threat or use of nuclear weapons should be compatible with requirement of the international law, particularly law applicable in armed conflicts, those of principles and rules of international humanitarian law. as well as with specific obligations under treaties and other undertaking which expressly deals with nuclear weapons. However, in the view of the current state of international law and of the elements of fact at the disposal before the court, the court cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in the extreme circumstance of self-defense, in which the very survival of the state would be at stake. In the next place, we will see again prohibited method of warfare. The concept of method of warfare encompasses any tactical or strategic procedures meant to outwit or weaken the adversaries. The limitations or prohibitions to resort to a specific method of warfare stipulated in international humanitarian law are predicated on three premises. Premise number one, the choice of method of warfare is not unlimited. Premise number two, the use of method of nature to cause unnecessary suffering or superfluous injury is forbidden. Premise number three, the only legitimate object of the war is to weaken the military forces of the enemy. In particular, international humanitarian law prohibits certain kind of attacks. A few brief comments will suffice here. So let us see what are the certain kind of attack they are specifically prohibited under international humanitarian law. Number one, attack against the civilian population and civilian objects. One of the cardinal rules of international humanitarian law is that belligerents must distinguish between military objectives on the one hand and civilian object on the other. International humanitarian law prohibits attack on a civilian population or individual civilian, terrorizing the civilian populations, civilian object, reprisal against civilian or civilian object, hostage taking, use of human shield, pillage and starvations as a method of warfare are totally prohibited under international humanitarian law. Civilians are entitled to protection only as long as they do not take part in hostilities. Even those attacks directed at legitimate military objectives are regulated by international humanitarian law. Such attack must not be indiscriminate, that is, the weapons utilized must be capable of being directed at the specific military objective, and the means used must be in proportionate to the military necessity. The principle of proportionality prohibits attacks even when directed at military objective, if they may be expected to cause incidental loss of civilian life, injury to civilian, damage to civilian object, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. Perfidy. Unlike ruses of war, which are lawful, perfidy is outlawed in international humanitarian law. Perfidy means act inviting the confidence of an adversary to lead him to believe that he is entitled to or is obliged to accord protections under rules of international law applicable in armed conflict, with intent to betray that confidence. Well-known examples of perfidy are the fleeing of an intention to negotiate under a flag of trust or of a surrender, the fleeing of an incapacitation by wounded or sickness, the fleeing of civilian non-combatant status, and the fleeing of protected status by the use of sign, emblem or uniform of United Nations or of neutral or other state not party to the conflict. Third, giving or ordering no quarters. Under international humanitarian law, it is prohibited to order that there shall be no survivors, to threaten an adversary therewith, or to conduct hostility on this basis. Most cases of perfidy and denial of quarter are grave breaks of international humanitarian law, and hence they are war crimes. Number 4, improper use of emblem, flags and uniforms. Under international humanitarian law, improper use of protective emblem, that is the Red Cross or Red Crescents or Red Crystals, or the flag of truce, being a white flag indicating readiness to negotiate, and of the emblem of United Nations. The flags or military emblem, insignia or uniforms of neutral or other state which are not party to conflict. Number 5, prohibition of attack against occupants of an aircraft in distress. I shall provide that no persons parachuting from such an aircraft which is in distress shall be made the object of an attack during his descent. It says that in event of his reaching the ground in the territory controlled by the adverse party, he shall be given an opportunity to surrender before being made the object of attack, unless it is apparent that he is engaging in a hostile act. But airborne troops are not protected by these very articles. Next, let us see limit to the conduct of hostilities in non-international armed conflict. The main rules applicable during non-international armed conflicts are to be found in the Common Article 3 of the Geneva Conventions. They are a part of general and universally recognized international law, as International Court of Justice rightly highlighted in 1986 in the famous case of Nicaragua. Protocol 2 has developed this obligation by making them more specific without introducing major innovations. But its provisions are binding only to states which are bound by Protocol 2. Article 3, common to the Geneva Conventions, specifically prohibited violence to life and persons, in particular murder of all kinds, mutilation, cruel treatment and tortures, the taking of hostages, outrage upon personal dignity, in particular humiliating and degrading treatments. But it is the fact that Article 3, common to the 4 Geneva Conventions, says nothing on the limit to the conduct of hostilities in non-international armed conflict. It is pertinent to mention here that way back in 1968, United Nations General Assembly passed a landmark resolution, that is resolution number 2444, which was equally applicable in all armed conflict. The 3 basic principles highlighted by these resolutions are: number 1, the right to choose method and means of warfare is not unlimited. Number 2, it is prohibited to attack the civilian population as such. Number 3, the distinction must be made at all times between combatant and civilians. So my dear students, so let's go to the last part of this lecture, that is the conclusion. The basic concept for limitation on warfare has already been in the right from the Declaration of St. Petersburg in 1868, and that declaration is still valid. The operative part of declarations is worthiness to repeat, which says, the only legitimate object which states should endeavor to accomplish during the war is to weaken the military forces of the enemy. For the purpose of this, it is sufficient to disable the greatest possible number of men. That this object would be exceeded by the employment of arms which uselessly aggravate the sufferings of the disabled man or render their inevitable. That the employment of such arms would therefore be contrary to law of humanity. It is also worthwhile to recall famous Martin clause, which provide that in cases not covered by treaty provisions, civilians and combatants remain under the protections and authority of principle of international law, derived from established customs, from the principle of humanity, and from the dictate of public conscience. My dear student, from this module, it follows that Hague Law and the Law of Geneva have been merged in Additional Protocol 1. Protocol 1 is at present binding on the majority of states, but not on all of them. But most of the provision of limits on waging war are considered as customary international humanitarian law, and so all parties to conflict are bound by these rules with certain exceptions. So I thank you all my students for your cooperation and the patient hearing. Thank you.